transitions, we're here to help. Visit caringtransitions.com. Caring Transitions, embracing new beginnings with confidence.
Patriot Channel 125 and on the Sirius XM app.
We still live under the Biden-Harris economy. One way to save money for you and your family and not sacrifice one bit service is to switch to my cell phone provider, and that is a veteran-owned company known as Pure Talk. The beauty of Pure Talk is just like Verizon, AT&T, and T-Mobile. They use the same cell towers. They use the same 5G network. You get the exact same service, and the average family.
Drive to Costco, Perrysburg.
Costco gas station.
You can get a free phone from Pure Talk, and you get a much better deal. You don't need, for example, 4 lines. You don't need an activation fee, and you don't need, 2 or 3 year contract paying, hundreds of dollars a month. It's crazy. Anyway, if you switch to Pure Talk today, they will give you a brand new Samsung Galaxy for free. Qualifying plans start at just $35 a month. You'll get unlimited talk, unlimited text, 15 gigs of data, mobile hotspot, roaming, all on America's most dependable 5G network, the same as the big carrier. $35 a month.
Should have brought some of my medicine with me, though.
And get your brand new Samsung
Still gotta
Galaxy
stop at
for
Costco.
free. It's simple to make the switch. It's fast. It's easy. You dial pound 250 on your cell. You say the keyword "save now," and that will be done immediately. Pound 250 keyword. Make the switch. Save money for the exact same service to my wireless company, a veteran-owned company called Pure Talk. All right, that's going to wrap things up for today, but let not your heart be troubled. We are loaded up. Part 2 of my interview with President Trump on Air Force One. This interview went on for about 50 minutes. I didn't think it would go on that long. I was grateful for the time. Also, Tammy Bruce, we will talk about the progress. She's working as a spokesperson for Marco Rubio at the Department of State. The latest with what's going on here in the Gulf states, the latest what's going on with Putin and Zelensky, and
yeah, they're pretty close to me.
All going to go down tomorrow. Aaron Cohn on Iran and the question of how America and Israel will do with the possibility of them still pursuing nuclear weapons. Kellyanne Conway, Tommy Lahren, much more. Set your DVR, 9 Eastern. If you're in Doha, it's 4 a.m. Because that's what time we'll be doing the show. Anyway, we'll see you tonight. Thank you for making this show possible. And back here tomorrow, we'll actually be in the UAE in Abu Dhabi, and we'll broadcast live as we wrap up our trip. What an incredible week it's been, I got to tell you. Historic in so many ways and beneficial to our country as well. See you tonight from Abu Dhabi tomorrow. Thank you for making this show possible.
Lanny went to college.
Yeah, I'm about 40 minutes from there. Gotta drive kind of past the house to get there.
$1.6 billion order from Qatar, one day after announcing an order from a company in Saudi Arabia. The Qatar deal is the biggest order of 787s and wide-body jets in Boeing.
Okay, my friends, we're testing the tubes. And it looks like they're working. That's tremendous news. Hello, my beautiful friends. What an amazing day it is. And welcome back. Very nice to see you.
Yeah, it's only 68 here because of the rain.
Q today.
Very comfortable.
Bunch of business to attend to. What are we starting off with? A victory from the Western District of Pennsylvania. You can see this is an opinion that we're going to be looking at today, which is a victory for the Trump administration on the Alien Enemies Act, the AEA. And remember, a big part of this debate, can Trump issue this proclamation and deport these people afuera, out of our country? And one of the holdups on this was, well, actually, Tren de Aragua and MS-13 don't qualify as alien enemies. There wasn't actually an invasion. There wasn't actually an intrusion or predatory incursion. You know the language. And this judge came back down and said, actually, yeah, there is. We really can't second guess a lot of those decisions. And we'll read through it. A nice, good one coming out of Pennsylvania. So we're starting to see a real big split on this. Yesterday on the show, we spent some time talking about Trump petitioning the Supreme Court, knocking on their door and saying, hello. And that should be rectified by the Supreme Court. So we know that they want the Supreme Court to come in and resolve a lot of this. So we'll talk about that. Then we'll turn our attention to the Kilmar situation. Speaking of alien enemies, we remember Kilmar Abrego, wife beater Garcia. Well, he came up today in the congressional hearing, and we got Marjorie Taylor Greene. That's the case to go bye-bye, saying that she is innocent because of judicial immunity, saying she's above the law. And this came up this morning, courtesy of our friend Economath, was saying that Judge Dugan has a solid argument that the feds arresting people in her courthouse is a violation of the Constitution, saying she's got privilege under different positions, and we'll see if those same arguments emerge. You can see Economath was sending that this morning during the members only stream, and it was a lot of fun. So that popped out. They filed a motion to dismiss, and so we'll see what that looks like, of course, here. Now, in addition to that, we'll take another look at the indictment. We did talk about this morning on the members only stream, but we'll just run through this again. We spent a lot of time on the Dugan complaint, which is the criminal complaint, but this is now just the 2-page indictment, which was signed off on by grand jurors. And grand jurors are now stamping their seal of approval on her criminality. It's not just a criminal complaint that came from an FBI special agent. It's also from a grand jury of her peers, which we'll talk about. So that's the Dugan case. Then we'll wrap it up with this impeachment situation, because this dude born in India, who's a representative who can hardly speak English, is now impeaching the president. Finally submitted his articles of impeachment. And we've been waiting for this for a while. We're like, will you just do it already? You guys keep screaming about, dictator and constitutional crisis and end of democracy, and then they won't even impeach him? Like, put your money where your mouth is. At least this dude, who can't even speak English hardly, is putting his money where his mouth is. And what's funny is the Democrats are like backing away slowly from this. They're like, dude, now's not the right time. Trump impeachment. The Republicans, I think, are pretty excited about this. Like, yeah, no, impeach away, do it. That's why we've been saying, yeah, do it, do it. If you're so tough, just go ahead and do it if you're so concerned. And then they never did it. Now they're doing it, and the Democrats are like running away from this. So it's pretty funny. I got this queued up. The House leadership was there, and they got asked some questions on this. Like, well, that's up to him, and there's a bunch of independent people in the House of Representatives, and they can do whatever they want, blah, blah, blah. So we'll go through all of that today and get into it. Now, you may notice we're not covering Diddy today. I think we got our fill and taste of Diddy yesterday. So the point is, there is an amazing individual who's covering this. Of course, you know him as Joe, Good Logic, right next door. So he's there in the courtroom, and he's going to be able to weigh in on the credibility. What did they sound like? What did they look like? Did the jury buy it? And all those details. So I'd encourage you to go check out his channel, our friend, Good Logic, right next door on YouTube and elsewhere. He's on X covering it too. And so we'll hand it off to his good and very capable hands. I'm sure there's a lot to get into over there. So today we'll stick to this business. We had a great members only stream this morning, and we're grateful to our friends who joined us on the morning. Thank you for becoming members. You may see that sometimes this is going to pop up throughout the screen now because we're trying some new technology. You can see. Oh, hey, welcome, Anthony Stokes. And of course, we'll say what's up at the end, but you might see this stuff pop up on the screen because we're checking. Systems and more, but we're excited. So we got business to attend to. Now let's get started with this nice case in the Alien Enemies Act matter, starting here. And are we coming in loud and clear? We can just confirm in that we're loud and clear. Everything's good. We've got, I think everybody's saying we're coming across loud and clear. Okay, cool. So we're on Rumble. Rumble's looking good. Hopefully, just confirming here. Thanks for understanding. Rumble's loud and clear. Amazing. All right, so good. Very cool. All right, so without any further ado, let's get into it. Let's see, are we stuttering? Somebody saying we're stuttering? I got 0 frames dropped on my end. Glitches, locals. Great on Twitch. What's up, Idiot HQ? Great to see you. Sounds good over there. All right, hopefully it's all good. 5x5 says Chetty Mo. All right, cool. We're going to keep this train on the track. Let's go, baby. All right, here's the deal. A victory for President Trump. The AEA. Let me start that over again because I forgot to press that button. Here we go. A victory for President Trump. We see this case is coming out of the Western District of Pennsylvania, and a victory for the president is a victory for us since we elected him. We didn't elect these judges. But what has happened is in these cases, you see this one is involving ASR, and ASR is not an organization, it's an acronym for a person's name. ASR is an individual who doesn't want to get deported and is suing the government essentially to say, you can't have lawful detention over me, you can't deport me by invoking the Alien Enemies Act. And what we've seen here is judges all across the country have found little justifications to find in their favor, certifying them as class action gangbangers, saying that they're not getting proper due process, basically holding Trump in contempt, ordering discovery, and just kind of mucking the whole thing up. Even the Supreme Court has issued a stay and ordered Trump to stop the removals of a lot of these people. But now this decision comes out of Pennsylvania, and this judge gets it right finally, and we're going to see, I think, a lot more of this as the forum shopping starts to dissipate. Remember, they went and picked the most favorable judges for them to give them the rulings that they wanted, and now we're seeing some actual legal logic start to bubble up. So here is what is happening here. The person who is in this case is called ASR. This is a Venezuelan man who's an illegal, currently in immigration custody, and they say he's subject to the AEA, Alien Enemies Act. He's got to go. Now, he has requested that this court in Pennsylvania say these three things. One, that Trump's proclamation is not in alignment with the Alien Enemies Act. Okay, so Trump came out and issued an order, and that order is out of the law. The law, Alien Enemies Act, was passed by Congress. It says you can use it for these things. Trump is not using it for those things, therefore it is unlawful. They also want to say that the due process is currently insufficient, and so that's generally what the Supreme Court has told us, is notice and opportunity to be heard. Okay, do you have notice of what's happening to you so you can challenge it? And is there an actual opportunity to do something about it? So they want a lot more due process, and the judge is going to find in their favor a little bit more on this. But the big one is this first attempt here, right? This would invalidate Trump's entire proclamation is the theory. And then they want other relief. Now, the judge writes this case, the Alien Enemies Act,
dog food,
significant issues to our country and to us that are deeply interwoven with the constitutional principles upon our founding. And so we have to begin by stressing stuff that we are not resolving right now, right? It's a very prickly position. Now, this court is not resolving the question of whether the president may direct the removal of certain people, and the court is not resolving the question of whether the president, okay, so kind of making a Venn diagram, kicking the president outside of that, because we have a real separation of powers problem if the judge is ordering the president to do anything, as you can imagine. And the court is not resolving a lot of those things. And third, the court is not resolving the question of whether individuals who are subject to removal are entitled to notice, okay? Like, that's already been decided. The Supreme Court has said you already are entitled to notice, right? The SCOTUS said that. We're always fine with that. You're entitled to notice and an opportunity to be heard, and you can go file in habeas in Texas. They didn't want to do that, though. They wanted class action gangbangers in Judge Zenas' courtroom. Instead, the question the court is going to answer here is this. So long as the government gives sufficient notice and due process, may the president issue a proclamation under the AEA doing what he did, right? Venezuelans, 14 or older, in the United States, neither actually naturalized or lawful permanent residents, so they've got no lawful status to be here, who are members of Tren de Aragua, which is a foreign terrorist organization. So can the president do that? That's all we're asking. And after extensive consideration, the judge says, drum roll, the court answers the question in the affirmative. Can the president do that? Yes. May he issue a proclamation? Yes! Obviously, he's the president. So therefore, the judge explains in detail. Because this court finds that the president can do this, the court denies their request for an injunction. Now, the court does say that you do need more notice, essentially. The notice, right? You got to give them a little bit more sufficient notice. And so accordingly, we'll make you do that. Now, here's the background, right? We know what the AEA says. It says the president may make a public proclamation, predatory incursion, enemy invasion. And that is exactly what Trump did. On March 14th, boom, comes into the White House, says we're taking care of business, TCB. It says Tren de Aragua is closely aligned with and has infiltrated the Maduro regime, and they're terrorizing our country, right? There's a whole proclamation there for the record. Writing, as a result of the foregoing...
For the next 2 weeks at minimum. Not just the weekend.
Attempting and threatening an invasion or predatory incursion, right? Those are those legal terms of art. We're going to say, many different parts of the statute they're going to challenge. Now, they're not enemies. They're not like labeled enemy combatants with an enemy uniform on, carrying an enemy flag. No. It's a little different than that, but they would want you to have a much more narrow definition of who qualifies. Explaining, Trump concluded these things and wrote it into the proclamation. Now, the court is going to give us an overview of the law. It says, well, the Secretary of State...
Until he gets his new apartment.
And as the Supreme Court has explained,
Until they can move into their new apartment.
national security means a bunch of stuff. Things like national defense, foreign relations, economic interests, and more. And an entity that is designated a terrorist organization, they can challenge that.
Oh,
Okay?
the rainbow.
Tren de Aragua says, hey, wait a minute. We're not
fading, but
gangbangers. We just are innocent.
all the way across the top there.
How dare you? Well, then they can challenge that, okay? The law says they can go to the D.C. Circuit, and they can challenge that. If they say that we're not actual terrorists, there's a mechanism. I did not know this. This is hilarious. The gangbangers just go sue. We're officially, who are you a lawyer with? The ACLU would probably represent them, since they're basically an extension of Tren de Aragua anyways at this moment. So just go sue. Just say, no, we're not. We're not a terrorist organization. They didn't do that. And there's a bunch of procedures. And Congress can also have a remedy on this too, right? So there's a bunch of stuff they can do. The D.C. Circuit can hold the designation unlawful if it's arbitrary, capricious, contrary to the constitutional power, in excess of statutory jurisdiction, lacking substantial support, not in accordance with procedures.
It's coming in sharper
Congress
now.
can also override that. When you say, hey, Tren's a terrorist group, foreign terrorist organization, Congress can say no, they're not. So on February 20th, Rubio also found that Tren and 7 other organizations were FTOs, a bunch of them. Tren de Aragua, Mara Salvatrucha, Cartel de Sinaloa, Jalisco, Unidos, all of them. They're all on the list. And the record, writes the judge, supports the evidence. We also have 2 declarations that Trump submitted. The first is a declaration by this person called Selwyn Smith. This person's Deputy Assistant Director, aka DAD, for Homeland Security. His acronym is Dad Smith. And Selwyn, is that a dude? All right, so in Dad Smith's declaration, he provides significant background based on his personal knowledge and experience. Oh yeah, no, TVA, Tren de Aragua, their growth, their spread throughout the United States is rampant. Members are involved in illicit activity. They invoke fear and supremacy in neighborhoods. They take over Denver apartment buildings. They traffic women from Venezuela. They commit bank fraud, narcotics frauds. They traffic human beings, homicide, many other things. And they are now present in the United States, committing criminal activity in 40 states across our country and in Canada. And Dad explained that the NYPD reported a surge in robberies that they believe were happening by TVA recruits, right? You've got to go commit these robberies. Okay? Now, accused leaders of this group have also admitted they've got a complex network in Florida and Texas, and they ship their profits back to South America. And crews of the Tren de Aragua network are also involved in extortion and ransom schemes and more. This guy says they pose an extraordinary threat to the American public, obviously. Now, the second is a declaration by Michael Kozak, and he's a senior bureau official from the Western Hemisphere. He said in his declaration that he's also got extensive work in Venezuela and elsewhere. And according to him, he says U.S. government officials from the White House and the State Department have negotiated the highest levels with the government of El Salvador, with Maduro and his representatives in recent weeks, for those countries to consent to the removal to Venezuela and El Salvador some of the Tren de Aragua members. Kozak says, actually, yeah, we reached agreements to this effect so that foreign interlocutors would accept the removal of some of the Tren gangbangers. These arrangements were the result of intensive negotiations between the United States and El Salvador, and there were also representatives there of the Maduro regime. Right, so you've got MS-13 and Tren de Aragua, you got to keep them separate. MS-13 is the Gilmore case, and El Salvador, Tren, in Venezuela. Now, against this backdrop, the judge says, so that sounds like pretty good evidence, right? We've got 2 declarations from government officials all saying that this has to be considered. It's a real threat to the country. Here's why. Now, against this backdrop, the court turns its attention to the factual and procedural history of this case. Now, there's a big question over jurisdiction, and it eats up a lot of time. So we'll go through this quickly, but does this court have jurisdiction at all? This has actually been a big issue because habeas, right? The Supreme Court saying, Judge Mosberg, you don't have jurisdiction. You have to send this back to where they're being housed. That happened to be Texas. What happens in Texas is not favorable to them, which is why they want to keep it in D.C. when they have all the favorite judges. So the judge is going to walk us through this. All right, listen. Here's what happened. On April 15, not long ago, this person filed a petition. Now, on that same day, he filed a TRO. So filed this by himself, habeas petition, right, which we've never been opposed to. Neither has the DOJ. So if you want to individually file, because you say this is wrong, go for it. But you don't get to be certified as a class and then file a constitutional claim that then validates the entire proclamation everywhere across the country. It's crazy.
Yeah, it's getting pretty dark up ahead, though.
And then, I don't know if you've got the ACLU lawyers or...
It's driving right into you when you're listening.
And then motion for class certification. So then we get class counsel, which is going to be the ACLU gangbangers, right? They got appointed for the entire class by others. Now, this illegal represents, he says, you know, at the time he filed his petition, he says, I'm a Venezuelan man, probably a barber or a PhD philosopher or a makeup artist or something. He says, I'm at imminent risk of removal. Now, along with this petition, he also submitted a declaration from his gangbang lawyer. Now, in that declaration, the lawyer made the following statements. They said, hey, I'm a gangbanger lawyer, and on April 14th, he was detained here. He's a citizen of Venezuela born in 95. He was put on the intensive supervision appearance program. During that time, ICE arrested him and told him his neighbor reported him. Neighbor called, said, "You're a member of Tren de Aragua." Neighbor called him in. ICE asked him about his tattoos. Oh, ICE filed an I-213 accusing him of being affiliated with TDA. Now, while he was detained at MVPC, this is the lawyer speaking, he was in pending immigration removal proceedings with an immigration hearing scheduled in Elizabeth Immigration Court. So it sounds like parallel things happening, right? He's got two different bases for removal. One, Alien Enemy Act, being Tren de Aragua. The other, he's just an illegal. ASR denies that his tattoos are connected to Tren. He vehemently denies any connection to that organization. Now, clearly, we all know there was tattoos to remember his auntie who died when he was born. Yeah. Finally, according to his counsel, his lawyer, it appears that he was at grave risk of removal because he's TDA. So then on April 15th, this court entered a TRO, temporarily stopping his removal. Said, all right, we don't know. Hold on. Judge paused everything. Said, okay, we'll come back for a hearing on April 18th.
Yeah,
then,
she is.
Before that,
not nearly as bad, but she went home and went right down on the couch.
Texas, right? So they didn't move it, but I had the case. The government also submitted the declaration, yep, we moved him from Pennsylvania to Texas. The court then held a status conference, and the government said, well, we're in jurisdiction. She's like, no. After receiving briefs, everyone agreed that he was present when he filed. No longer there today, and because he was there when he filed, the court has jurisdiction. So the court held that the TRO would remain in effect, right? So everything would be paused, and it said, don't remove him from the country.
Oh, lightning up ahead too.
But he's got to get notice in English and Spanish, and he's got to have interpreters if they need them, and red carpet, ACLU lawyers, and other things, because they get no rights to do it, because they're ahead of the according to our government. Now, finally, the court informed ASR he was permitted to file a motion, and if he did, he'd have a hearing. So then we had another hearing, and it was about certifying a class. The court knows there's been a separate opinion on that.
Well, it's hard not to when you sleep together.
Now, then they filed the response, and the reply came in, and then we conducted the hearing. Now, during that hearing, two things occurred that are especially relevant here. With respect to jurisdiction and standing, counsel for Trump indicated that he could not guarantee this court with absolute certainty that the government will not deem ASR to be subject to removal in the future. Okay, like, you can't say that. There might be some other proclamation. He might come under it in the future. And second, with respect to notice, they said, we're currently giving 12 hours of notice right there. Okay, that's not long enough. They say, well, 12 hours, they get notice, and they can file or not. Otherwise, wait for time. Okay, like, it's like, midnight.
Fucking election day did this. All the people I ran into, I touched, baby.
If an individual indicates that he wants to file, then he gets another 24 hours. And if he does file, then they won't remove him. So this court begins by asking these basic questions. Do we have jurisdiction over this case? She's going to find, yes, we do, and make a ruling. As the Supreme Court says, federal habeas gives district courts jurisdiction where they're in custody. Now, even though you moved this guy, he was here and then moved. He was scheduled for an immigration hearing in New Jersey on April 15th for another reason, right? So this kind of complicates things because he was also being processed under the INA. So think about it like two separate tracks or like two separate almost crimes or prosecutions, right? Both leading to removal. But the INA is just regular immigration stuff. It's not lawfully here. And the Alien Enemies Act is Trump's new proclamation. So if I take those both together, the court is left with the following questions. So gosh, if he has always been in custody under the INA rather than the AEA, right? Because Trump is saying, actually, when we had him in custody under the INA, which is over here. So that's why we moved him. So you actually never had jurisdiction. They filed in the wrong spot. They said, well, if that's true, if he was in New Jersey, then why'd you move him to Texas? The court can't square this circle, and it seems like his abrupt movement is evidence that he was then in custody. So she's just going to say, I find that anything else, right, I have power over this guy. The evidence to which they cite does not
Small
say that they
accident,
determined that he was not removable under the proclamation. And in short, while the court has before it indications that he was in custody under the INA, which they're not suing under, the court finds that to believe those representations would be to exalt form over fairly significant evidentiary substance. And so, the court is going to find that on April 15th, when he actually filed his habeas petition, he was in custody pursuant to the proclamation and the AEA, right? So I think you can probably split hairs on that. And she's just going to find in favor. She's ultimately going to give us the outcome that we want, so it's not really consequential. Accordingly, this court had jurisdiction over him and finds that even if they did move him from removal proceedings or to removal proceedings under the ANA, right? So, okay, well, we got this guy under the AEA, but now we're not going to use that. We're just going to use the INA and drop that other case. Like, we got this guy for, possession of narcotics, but we also got him for possession of dangerous drugs, right? And some other classification of drugs. And so then you just pick one, drop the other, pursue that claim, and that's your discretion to do that. She says, well, you might, but I'm just going to hold that you had him basically in custody for both reasons, and the fact that he filed this while he was in custody gives me jurisdiction over it, and I'm going to liberally construe the custody requirement for habeas. And so, now it's about standing. Do they have the ability to sue? The court finds that yes, he does have standing. He was personally facing removal, and Trump is kind of saying, well, we're not actually subjecting him to the AEA though. Now we're just going to use the INA, not the AEA. He says, well, if we assume that he's no longer subject to the AEA, then we have to ask whether mootness applies and more, whether this can come back, right? It's like, well, if I dismiss this, this is capable of repetition yet evading review, which is this concept that you don't want this to come back, right? Because then Trump could do this every time, kind of like file something and then change his strategy and then dismiss it, and then the court judicial review, or could have judicial review as to the interpretation and the constitutionality of the act, right? So the Supreme Court came back down and said, judicial review of this act is limited. Judges can't just appropriate more. They said reasonable time in the Supreme Court that actually allows them to seek habeas in the proper court. And
I'm
the
almost
court
there.
also may theoretically assess the constitutionality of the AEA, and although the issue is well settled in favor of the act, the court may assess, is the individual subject to the AEA? A question that they're not presently pressing upon this court, because that's in habeas, right? That should be filed elsewhere. Now here, they tell us. However, the judge says, this illegal wants a more intensive inquiry. When he says that Trump and his proclamation cannot survive and must be declared illegal because they are simply incorrect as a factual matter, right? This is there is no predatory incursion argument. There is no invasion argument. Tren de Aragua is not an alien enemy. And here's what this judge says. You've invited me to make that assessment, but I'm going to decline to do that. Not going to happen. The court first notes that in the JGG case that went up to the Supreme Court, it doesn't give me permission for this court or any court to weigh the truthfulness of the factual representations within the presidential proclamation. Trump said this is happening. The judge can't say, actually, no, it's not, because I read CNN and Jake Tapper and help us out. You don't get the right to say that, Judge. He's the president. You're saying that judicial review is limited, and the proper subjects are interpretation, constitutionality, is an individual, in fact, an alien enemy, and more. And in another Supreme Court, they also expressed hesitancy to wade into weighing whether a state of war even existed. That's not for the judges to decide. A reality that triggered the declared war component of the AEA and permitted the president to use the act. They can substitute their judgment for that. Now, in this same vein, the district court for the Southern District of Texas that we talked about yesterday recently concluded that after a court construes the meaning of these terms like invasion,
Oh, the lights are out here.
It's up to the executive branch to determine whether that has occurred. Now, as to this
Traffic
decision,
lights are out.
the court may not delve into whether
Street
the
lights
executive
are out.
branch possesses sufficient
Wonder if
support for Democrats.
Costco's
Well,
closed or not.
Trump should have done a more strenuous analysis on Tren de Aragua, or whether the court agrees. You don't get to make those interpretations. That analysis would require the executive branch to disclose to the court the undergirds of a finding of what a predatory incursion is. And that is contrary to the law. They're not required to answer to you before they make those decisions. Before leaving the subject, this judge says, the court also notes, the Southern District of Texas also concluded that the presidential declaration invoking the AEA must have sufficient.
Yeah, it must have
facts
came
to
down
support
hard
so
here.
The court can make a decision. Now, you don't have to disclose everything, but you got to give the court enough to say, okay, look, that's good enough. That meets the standard.
Well, the gas
Now,
station's
this
open.
articulation of the law appears reasonable, appears correct to me, says the judge. And as the court finds below, Trump's proclamation meets this standard. It's lawful. Therefore, the court doesn't need to spend extensive time working out the nuances of any of this. They did it in Texas. And the court assumes, without deciding, that the Southern District of Texas is correct on this issue and proceeds accordingly.
All right.
And so now let's get into the
Right
law.
here.
Of course, we know what the standards are for a preliminary injunction. One of those standards is the party who wants the court to do something.
Yeah, it doesn't look like it's raining real hard right now. Let me
Are they
see.
going to win the case? When interpreting
It's
the
just
statute,
sprinkling
the
right
court's
now.
job is to look at the ordinary meaning at the time Congress
All right, brother.
enacted the statute.
I may go online later for poker. If not,
Now, in the
I'll see you tomorrow. Oh no, tonight. Remember? Oh yeah, I'm gonna do the scanning stream. I will set that up tonight.
Now, what happens here is
Later, brother.
Trump says, here's the meaning.